All right. So, you know what I'm going to do just to provide some context here? I'm going to recap what my description of what Jackson does here. Just a paragraph, and then I'm going to go to the highlights to illustrate what I say in the paragraph. So when I introduced this show, I told you all that Jackson extensively denigrates her colleagues on the SCOTUS bench as ruling in an unprincipled and unfortunate manner, in delivering a decision that uses logic only such as it is, as making an even bigger mistake than I had realized, is as lacking or in deviating dramatically from ordinary common sense. She's talking about her 8 colleagues. As engaging in Calvinball jurisprudence in which there are no fixed rules. The only rules are it's Calvinball. There are no fixed rules. And the second rule is Trump always wins. She's telling her colleagues on the Supreme Court that their rulings lack legal reasoning, lack integrity, lack logic, are unprincipled, are bigger mistakes than even the genius Ketanji Waffle House Jackson could have imagined. And the guiding principle for the majority is not law or constitution. It's Trump always wins. That's what she's telling her colleagues. I guess she's tired of having lost 17 times in a row on these Trump cases. So with that context, let's take a look at what she has to say. Justice Ketanji Waffle House Jackson, concurring in part, so she's happy that the APA claim is going to remain with the district court, dissenting in part. She would have made Trump pay the money. This past spring, so just months ago, the Supreme Court took a mere 9 days to address a difficult and nuanced legal issue. Those were cases like California. Here's California, where the court ruled in favor of Trump. Jackson doesn't like that, of course. Jackson says, I viewed the court's intervention in those earlier cases as equal parts unprincipled and unfortunate. By the way, look who Jackson is citing as her legal authority. She's quoting her own dissent. Jackson could not find any other justice that holds this opinion to cite as support. The only support Jackson has is Jackson. She's quoting herself here. As it turns out, Jackson writes, the Supreme Court's decision was an even bigger mistake than I realized. The Supreme Court's reasoning, the majority, the winning reasoning in California was not only at the least underdeveloped and very possibly wrong, but it also evidently resolved more than the jurisdictional issue in question. A half paragraph of reasoning issued without full briefing or any oral argument because it was a preliminary injunction case, so there's nothing on the merits, thus suffices to partially sustain Trump's abrupt cancellation of hundreds of millions of dollars allocated to support life-saving biomedical research. Again, she's presuming this end, right? It's equally reasonable to argue, you know what, this hundreds of millions of dollars is going to make work jobs for liberal women who paid too much for academic degrees of no economic value in the private market, who the government's given these jobs to so they can continue to contribute to Democrat politicians and live their cat mom Chardonnay lifestyles in luxury DC apartments in Northern Virginia after they've divorced their husbands or were never able to find one in the first place. A complete hackorama guided by corrupt DEI cult principles and racism, which is what Trump's objecting to. That's where this money was going. But Ketanji's going to say, no, it was life-saving biomedical research. How many of these broads in these jobs with these worthless degrees, You've all worked with these women. I've worked with them. If anyone who's worked as a corporation has worked with these women. If not in biomedical research, then in marketing, right? In human resources. Jackson continues, today's order, an evenly divided court, neuters judicial review of grant terminations by sending the plaintiffs on a likely futile, multi-venue quest for complete relief. She doesn't like that the claims are split. APA to the district court, contract claim to the Court of Federal Claims. She imagines, by the way, you'll see this pattern repeated throughout. Ketanji Jackson cannot accept that she may not have the authority to give a definitive answer to these questions that she wants. She cannot accept that maybe this is not something the Supreme Court should even be involved in. She doesn't like the money's not being paid. The only acceptable answer is that the money be paid, that Trump be forced to pay this money. And whatever's necessary to do that is what needs to be done, including if that means that the Supreme Court claims ultimate authority over all the things. Because a completely unacceptable answer to Ketanji Jackson is that the conclusion is not to her liking. Then she says, this Supreme Court also lobs a grenade. Lobbing a grenade. That's how she characterizes the legal reasoning and decision-making of the 8 other justices on this court. They lob grenades. With potentially life-saving scientific advancements on the line, the Supreme Court turns a nearly century-old statute aimed at unreasonable agency decision-making into a gauntlet rather than a refuge. So Jackson would make the APA a protection for everybody that's threatened by Trump's policies, meaning the policies we voted Trump to implement. They should have a refuge from the political will of the American people. The APA should protect them. Again, remember, I told you earlier, the purpose of the APA is to protect the American people from arbitrary and capricious decision-making by government hacks. How Ketanji Jackson is characterizing the APA here, this nearly century-old statute, is as a refuge for the government hacks from the political will of the American people. It's exactly backwards. So NIH does research. Grant terminations have been rare. That's not legal reasoning. No offense, ladies, but this is how women argue. Well, you never did it that way before. Why are you doing it that way now? That's not the question. Trump doesn't lose his executive authority because previous presidents were pussies. He either has the authority or he doesn't, and he does. The fact that other people didn't do it, other presidents didn't terminate these grants, doesn't mean Trump lacks the authority to do it. The NIH implementation of grants money changed dramatically in February 2025 after the president elected by the whole of the American people to exercise our political will signed a trio of executive orders instructing the government to stop diversity, equity, and inclusion initiatives, stop gender ideology promotion. Who voted for this? Stop COVID-19 lethal mRNA vaccines. I voted for this 1,000 times over. In response, the NIH leadership issued a series of directives terminating grants, stopping the money. A frantic process followed. When the dust settled, thousands of grants had been canceled. Including those supporting research into suicide risk and prevention, HIV transmission, largely in the third world, by the way, Alzheimer's, and cardiovascular disease. What are the big breakthroughs? These people have been spending billions of dollars on our money in Alzheimer's research for at least 30 years. 30 years ago, I was working at the Harvard School of Public Health, and their big initiative was Alzheimer's research 35 years ago. How much advancement have these? women of a certain age that failed to secure a husband before they timed out of the dating market, how much advancement have they made in Alzheimer's? Anybody seen it? How about on cardiovascular disease? Nope. HIV transmission? You know what stopped the bulk of HIV transmission in America? It wasn't drugs. It was people changing their behavior. The NIH doesn't change behavior. The plaintiff sued in federal district court, arguing that the NIH had issued arbitrary and capricious orders under the APA, violated the separation of powers, the spending clause, blah, 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 blah. Handling the case with dispatch, she likes, Ketanji Waffle House Jackson likes the trial court. So she says nice things about them. The trial court handled the case with dispatch. Decided the APA claim is really a breach of contract. Let's see. And analyzed the Trump's claim that the APA claim was a subterfuge, is Trump's argument. This is really a breach of contract claim and therefore belongs in the Court of Federal Claims rather than in district court. Strangely, the district court here declined to give up jurisdiction over this decision. The district court, as it does here, the government, Trump, took inspiration from this court's recent order in California. You know, inspiration from the Supreme Court precedent on an essentially identical case, a money grant termination case. But the district court, Jackson says, concluded that California was somewhat different. Remember who the district court cited from the California case in support of their decision to ignore the majority in California? The district court cited Jackson's dissent in California. The trial court said, while the breach of claims contract for money damage go to the Court of Claims, she doesn't want to give it up anyway. She just wants to keep it. So California was different, relying on Jackson's dissent in California rather than on the controlling majority opinion in California. The district court then proceeded directly to a bench trial, so no jury. That same trial court, unelected black robe tyrannical inferior district trial court judge just decided themselves that Trump loses. Just like Judge Erdogan in New York. That was a bench trial too. Remember the $500 million in fines that just got reversed by the well-known conservative Court of Appeals in New York State. Judge Erdogan's $500 million fine against Trump, also a bench trial. No jury there. It's weird how that happens. The trial judge says the executive orders and therefore the terminations of the money were arbitrary and capricious and had to be set aside under the APA. The court explained that DEI, the central concept the executive orders didn't like, was nowhere defined. Again, no one goes to the shelter for a pit bull and comes back with a chihuahua. That wasn't defined. No one knows what DEI means. The NIH has been issuing DEI grants before Trump came in for decades. And suddenly they don't know. They don't know what their own DEI means. The court found as a factual matter an unmistakable pattern of discrimination against women's health issues, racial discrimination. The only racial discrimination in these grants was that they were favored to minorities. They were favored to black and brown people. They were favored to women researchers and against straight white men. That's the racism. That's the DEI that Trump is ending. The trial judge, and I love you can the tell is always when they use this kind of emotionally charged language. They don't say the executive orders were arbitrary and capricious. They say they were breathtakingly arbitrary and capricious. So today, without any showing, meaning any legal reasoning, Jackson says, this Supreme Court, her colleagues, give Trump much of what he asks for. It splits the money termination from the APA issues. Let's see. I want to get to the meat of this. So basically, she's saying it'll let you argue the APA issues in federal district court, but it's going to make you take the money issue to the Court of Federal Claims, citing Barrett. But it gets worse, Jackson says. From the logic, such as it is, shame, insults, guilt need to be right. From the logic, such as it is, of the Supreme Court's order, her colleagues, it appears that a plaintiff's pursuit of money in the Court of Federal Claims will be in vain because the statute that creates the Court of Federal Claims forbids that relief. They're going to lose in the Court of Federal Claims. That's why they're not there. That's why they're trying to sneak this into district court. She then says the Supreme Court obliquely rewrites the plaintiff's complaint and the APA. So she's saying now the majority here is not adopting Trump's argument, not accepting the plaintiff's argument. They're making their own argument. The gall, the audacity of the progressive left to make this argument that the court's rewriting its own argument, its own reasoning, not of the parties, is galling when you consider Obamacare. When it came to the Supreme Court and Chief Justice Roberts, if you read that decision, he explains over and over again why Obama's arguments for Obamacare were not constitutionally sufficient. And keep in mind, Obamacare had argued again and again and again. Sorry, Obama had argued again and again and again. Every Obama government, Obama administration argument for Obamacare said, listen, this is not a tax. Why did he say that? Because if it were a tax, it would have had to originate in the House of Representatives, and it did not originate in the House of Representatives. So to maintain its fake legitimacy, Obama had to insist Obamacare was not a tax, that they had other constitutional authority for Obamacare. And when it got to the Supreme Court, Chief Justice Roberts looks at all the other claimed authority for Obamacare and says, nope, 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 nope. Nothing Obama argued was justification for Obamacare. But what did Chief Justice do? He made an argument for Obamacare that not only Obama had never made, but had disavowed. Chief Justice says this is unconstitutional under every argument Obama's made. But it's a tax. It's constitutional as a tax. Unbelievable. The same Chief Justice, never mind. I don't want to get too far off track. So now she's complaining that the Supreme Court is obliquely rewriting arguments as if they don't do that. Let's see, more meat here. A majority of the court rightly rejects Trump's argument that the whole case belongs in the Court of Federal Claims. So she's glad that at least the APA claim is staying with the federal trial court. 5 members of the court reject Trump's argument that the whole case should go to the Court of Federal Claims. The district court may still exercise jurisdiction over the APA claim. But if they agree to that, the rest should have been easy. If the APA claim is going to stay with the district court, the money claim could have stayed as well. That's her argument. And obviously, it's the losing argument. Keep in mind, when she writes this, not even Sotomayor and Kagan are joining her here. The Supreme Court's order deviates dramatically from ordinary common sense. Again, she's talking about her colleagues. This Supreme Court turns to the Tucker Act and the Court of Federal Claims, but the Tucker Act has nothing to say about this case, in her opinion. Of course, the majority disagrees. Let's see. We're 2 hours in, so I don't want to waste time on a lot of her blather. Here we go. Whatever the Tucker Act and the Court of Federal Claims might say about the APA claims, it surely does not compel the bizarre claim-splitting regime my colleagues on the Supreme Court imposes today. So she's saying her majority colleagues are engaged in bizarre decision-making. Shame, insults, guilt need to be right. Here we go. In a broader sense, today's ruling is of a piece of a similar tone with this Supreme Court's recent tendencies. This is not written in a flattering way, folks. When the judiciary, according to Jackson, by the way, this is a quote here, right? Quote, right when the judiciary should be, I'm going to quote the whole thing. I'll read it. But note who she's quoting here. Jackson is again quoting Jackson from a losing opinion. She's quoting herself from one of her dissents. She's quoting an argument she made in a previous case that was the losing argument in support of her losing argument here. Jackson quoting Jackson. Justice Ketanji Waffle House Jackson quoting Justice Ketanji, I'm not a biologist. How would I know what a woman is, Jackson? Quote, right when the judiciary should be hunkering down to do all it can to preserve the law's constraints, what that means is to impede Trump, the Supreme Court opts instead to make vindicating the rule of law and preventing manifestly injurious government action as difficult as possible. Why are we restraining ourselves from stopping Trump? She continues, this is Calvinball jurisprudence with a twist. Calvinball has only one rule. There are no rules. This, my colleagues on the Supreme Court seem to have only two rules. That one, there are no fixed rules, and Trump always wins. That's how she's characterized the majority. If this were someone working for any business at a senior level, would management come to them afterwards and say, listen, can we chat for a minute? You seem to have a lot of trouble working well with others. Those of you who've worked for companies before, corporations before, right? Do you agree? I should do a poll. They would come to her and say, listen, I don't know what's wrong with your emotional intelligence, but these are your peers. You need to be able to work with them for the rest of your life. It's a lifetime appointment. You can't be continually disparaging them just because you're on the losing side of the argument. You are not superior to them. Unbelievable. Calvinball. At a time when the executive branch is racing to terminate federal grants on a mass scale, as if the executive branch isn't allowed to adopt its own policy, and according to too many courts to count, often unlawfully. Of course, she's talking about the unelected black robe tyrannical inferior district trial federal courts in 5 out of 40 plus districts. That's how concentrated and limited the lawfare is against Trump. She can't even count them all. She doesn't bother because she just wants this hyper emotional rhetoric. According to too many courts to count, they say it's unlawful. All right, those courts have said what Trump is doing is unlawful. What is it? What happens when it gets to the Supreme Court? You know, the Supreme Court on which you sit. Now it's 17-0. Supreme Court wins for Trump. It's not a mixed bag. These courts that are too many to count, who've said Trump's acting unlawfully, lose every single time that their bosses have to examine their reasoning and judgment. This Supreme Court has now constructed a deeply inefficient and likely impotent scheme of judicial review. She's calling Chief Justice John Roberts, Clarence Thomas, Gorsuch, Kavanaugh. She's calling them impotent. The court has done so without bothering to assess whether Congress intended such a scheme in a manner that requires second-guessing trial courts. The Supreme Court's not allowed to second-guess trial courts now. As long as the trial court comes to a decision that Justice Ketanji, Waffle House Jackson likes, oh, we can't second-guess that. What do you think she would do if a trial court issued a ruling that was favorable to Trump? She wouldn't second-guess that trial court? The ends justifies the means. The Supreme Court is muddying basic legal principles because they're not arriving at the conclusions she wants and unraveling valuable scientific research. This is a policy decision. Federal court judges, even Supreme Court judges, it's not their role to decide what scientific research is worth funding and what isn't. Those are policy decisions made by the political branches of government, not the Article 3 judicial branch Supreme Court. The only question the Supreme Court's supposed to be answering is, are the political branches of government making those decisions in a constitutional way? Do they have the authority to make those decisions? The Supreme Court is not a super legislature, a super president that gets to come in and say, well, I don't like how Congress and the president did it, so I'm going to substitute my own judgment. The approach the Supreme Court adopts today neither coheres legally, it's not legally coherent, nor operates practically. It's also impractical. Unfortunately, this newest entry in the court's quest to make way for Trump has real consequences. You are just the servants of Trump. You majority, my colleagues on the Supreme Court, you're on a quest to make way for Trump. That has real consequences for the law and for the public. For the public's sake, one can only hope. We can only hope. Will no one save me from this troublesome Supreme Court? We can only hope that the affected grant recipients can find a way to maintain their research studies long enough to give this Supreme Court a chance to change its broken mind. There you have it, folks. That's Justice Ketanji Waffle House Jackson.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.